The hearing kicks off with the judge confirming the defendant's identity. It may seem routine, but once your name is spoken in court, you're officially on stage. Every move from here counts.
Good morning. Are you Reneia Sigura?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
She will.
Ms. Sigura, in clause number 231869, I have a motion to revoke your community supervision. Shows that you were placed on probation July 29th of 2024 for the offense of theft of property with previous convictions.
Early in the case, we learned she was sentenced to prison but placed on probation instead. Think of probation as freedom on a leash, still walking around but always under watch, and if you tug that leash too hard, it snaps back quickly.
And that was a 2-year term in prison that was probated for 5 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of theft in aggregate amount January 29th, 2025 in Harris County, Texas. And is that true or not true?
When the violations are read, she admits guilt almost instantly. That honesty might sound cooperative, but in reality it shuts the door on leniency. Once you admit the violations, the judge is boxed in. Punishment is inevitable.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, in that you were at a location. You were arrested at a place where a crime had been committed with individuals who had previously been convicted of crimes. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
Give me a minute here.
Judge, I'd reviewed some of the Harris County offense material. She was essentially an accomplice while other people were committing theft in this instance.
I'm going to real quick look back at the pre-sentence report to see that all that the criminal, how many we've got.
A lot. I won't say it.
Oh, yeah, no.
Then the hammer drops. The judge reads her record: 7 felony convictions, 5 more arrests, and another new offense. This isn't just bad luck, it's a track record. No wonder the judge refuses anything less than the full 15 months. What do you think? Should repeat offenders still get lighter chances, or is this where the system must draw a hard line?
I'm not accepting this. My notes, I sent you to ISF already. And my note says it was a cap of 15 months at that time. And I wrote on here that you deserved the whole 15 months. And it's like Mr. Lewis was your attorney at that time. And he and Ms. Holmes are both doing quite the job for you. But 8 months with 7 felony convictions for theft, 5 more arrests, plus this one, and now you've been arrested again, is not something I'm going to accept. Absolutely nothing less than the 15.
The judge then lays out the choice crystal clear: accept 15 months or face an MTRP, which means probation revoked and likely prison time. This is the fork in the road, one decision that shapes the future.
15 months that was the cap in the first place. So it's either something like that, or it's an MTRP. I don't have to, y'all go talk about it. I'm deleting the paperwork. All right, go back with the bailiff. If y'all come up with something today, then that's fine. If not, we'll, but I deleted it. You'll need to redo something.
Don't say I told you so when I go down I have a note on my file that I argued for the full 15.
Well, then I don't, then why? Then throw it back in my face.
Well, I didn't on this one.
Well, it deserved it though.
Finally, we hear a comparison between counties. Some hand out light sentences, others go tough. Justice, it seems, depends on where you're standing. Big question for you: should sentencing be standardized across counties, or is local discretion necessary to keep balance in the system?
They gave her like 30 days time served.
But that's Harris County. They give 30 days time served on aggravated robberies.
They do like 45.
I mean,
they do 45.
That doesn't count. That's not.
They do 45.
Absolutely. When there's something like that, no way.